Lionel Mandrean is suing Stanley Apple in the amount of $3,900. Mr. Mandrean claims he paid for upgrades to his landlord's home while he was a tenant and says Mr. Apple refused to reimburse him when the house sold.
State your name, sir.
Lionel Mandrean.
Sir.
Stanley Apple.
All right. And, sir, you are suing the defendant for $3,900, claiming the defendant sold fixtures that didn't belong to him. So you're obviously saying they belong to you, because you can't sue him because he stole somebody else's stuff.
Correct.
Because you said them. All right. And, sir, you know why you're being sued, right?
The plaintiff allegedly paid for fixtures that I told him not to pay for, that I was not going to pay for, and now he's suing because he installed fixtures that I said I would never pay for.
All right, well, you look pretty serious about that thing, so I ain't got no reason to doubt you. Case dismissed. He got a smile, so I got to doubt you. He smiles, so he looks honest. First you sounded honest, he looks honest. So I'm going to let the case proceed. Tell me what's going on here, sir.
Thank
Lionel.
you, Judge. Basically, I've been living in Stanley Apple's house for the last 8 years. Stanley retired, moved out to Florida. He was a little concerned about leaving his house in California. So I told him, don't worry about it. I'll be the tenant. I'll take great care of your house. I'll treat it like my own. The issue didn't come until when he was ready to sell the house. And that's where all of our problems began. Because we had a good rapport. I sent him my check every month. We never had an issue.
You didn't take advantage of COVID?
No, never.
Nobody
left.
paid their landlord during COVID. The law got him out of that.
Luckily...
You're the only one didn't know what time it was, huh?
Well, luckily, I was still getting paid for my work, so...
Good. So you didn't want to cheat?
I didn't want to cheat. I'm an honest man.
As Lionel explains his 8-year tenancy, he paints a picture of loyalty and trust. He claims he cared for the home as if it were his own, even paying rent faithfully through difficult times. Yet, his upgrades to the property, including modern fixtures and bathroom improvements, became the core of this lawsuit. The law, however, distinguishes between repairs and improvements. Repairs maintain, improvements enhance. Only one of these typically qualifies for reimbursement. Judge Mathis listens, intrigued but cautious. The line between goodwill and overreach is thin. Viewers, what do you think? Was Lionel acting as a responsible tenant, or did he overstep his bounds?
Man.
He wins. That's the end of that, sir.
And I appreciate that, sir. However, he installed fixtures. Fixtures means fixed. If they were not supposed to be fixed in place, they would be called removals. They're not removals, they're fixtures, which means he has no justification to remove anything that's a fixture.
Well, if I may,
Yeah.
basically what happened was, I'm not saying Stanley's cheap or anything, but if given the choice...
He's not Stanley. He's Mr. Apple, I prefer. Don't you, Mr. Apple?
Yes, sir.
Thank you.
Okay, sorry about that. So Mr. Apple would always order or buy the least expensive products. And when I moved into the house, it had circa 1970s faucets and things like that.
If he didn't like that, he shouldn't have moved into the house. It's up to him. He took the house, and as is condition, there were no warranties that anything would be upgraded. Only things that were repaired were replaced, and that's what I did.
Mr. Apple, I've been with you for most of this case, but you're about to lose me. Seems like you've done this quite frequently.
I'm sorry, sir.
Seems like you've done this quite frequently. You've held this case together so well. Seems like you may have done this before with other tenants.
No, sir, I've never been sued in my life.
When Mr. Apple takes the stand, his tone is firm and calculated. He insists that Lionel installed those fixtures against his advice and without any promise of repayment. Judge Mathis challenges both men, one claiming fairness, the other citing law. Here, the term fixtures becomes key. Items attached to a property are presumed to belong to the property owner, not the installer. It is a moment of tension where legal ownership clashes with moral fairness. Should intent matter more than the law in cases like this? Or is property ownership absolute once something is installed?
This is the first time I've ever been sued, and I'm shocked, dismayed, and disappointed.
Well,
he's good.
Correct. But basically what happened was I replaced a lot of the faucets. I replaced the sink in the bathroom. It was, like I said, circa 1970s.
Give me the items precisely. Give me the exact items that you're suing for that you believe were to have been returned to you or paid to you for.
Okay.
Mm-hmm.
And I have evidence here of what before and after looked like. Oh, I need that. Sorry, and on the front list.
Something you needed? Okay.
Yeah, on the front is how much I paid for each item. Yes. So basically, the kitchen faucet, instead of, again, old type faucet, I bought a really nice, new style. New style that looked modern. This is, again, I plan to live there for a very long time. How
long was your lease?
Well, we kind of went month to month. So
what made you think what made you assume you were going to be there a very, very long time?
Coming up on Mathis Court with Judge Mathis.
Did you ask him or inform him? I'm going to put a new shower head in. I'm going to fix the sink, get new this and new that. Did you mention that to him?
And later.
We've been neighbors for about 3 years.
Have you gotten along?
Here and there. Some days we're good, some days we aren't.
The answer is no.
As Lionel presents before and after photos and receipts, the courtroom sees the transformation. Old faucets replaced by sleek, modern designs. But Judge Mathis's expression changes. He is not questioning the beauty of the work. He's questioning the legality of expectation. Without a written agreement, even visual proof may not secure a win. This becomes a textbook example of oral misunderstanding in tenancy law. If verbal agreements are so fragile, should tenants always put home improvements in writing before spending a single dollar?
Mathis Court is back with a case of Lionel Mandrean, who is suing Stanley Apple for civil theft.
Because there was no indication at the time that Mr. Apple was going to be selling the place. He was happy with me, I was happy with him, and we just continued this agreement. And then Mr. Apple contacted me and said he's selling the house.
Let me ask, when you were having these items placed inside, each time did you ask him or inform him, I'm going to put some a new shower head in, I'm going to fix the sink, get new this and new that. Did you mention that to him?
At the time, we had an understanding that I would take care of the property, anything that needed to be done. So these were things that I chose to do.
When he spoke to me, sir, I told him that I would pay for a replacement, not for an upgrade. And if he wanted an upgrade, he would have to pay for himself. Specifically, I told him that. And that is what I expect him to stand up to. Also, I gave him an extra $5,000 when he moved out as a relocation fee. That should pay for any and all troubles that he had.
Well, that was relocation fee. That was because I wasn't planning on moving, and he said, I feel bad that you have to move. And there you go. He gave me $5,000 to help with the move.
Not obligated to do that.
No, not at all. But one has nothing to do with another. He contacted me. He wanted to sell the house. I said, "Don't worry. I'll make sure the house looks great. I'll help be there when people want to come and look at the house." I was very cooperative. Well, anyway, the realtor and the people came in. And they wound up buying the house, the people that were looking at it, in less than 2 weeks. And everything that they pointed to, the sink, the shutters, the modernized bathroom, is what sold them on the house.
Hardly.
So those are the upgrades. So he sold his house in less than 2 weeks because I put in these upgrades that the new buyers loved.
Hardly. They got a bargain. They got a deal. And my ex-tenant, thank goodness ex-tenant, got $5,000 that he was not entitled to, and I gave it to him out of the goodness of my heart.
Right.
And this lawsuit is ridiculous.
Well, let me give you the law, sir. I've heard all the facts, and I've heard your rationale and your analysis. Let me give you my analysis and the law. And the law is you cannot remove fixtures when you either sell or move as a tenant. You can't touch the fixtures, and you should have had an agreement with him. Otherwise, you purchased it for your enjoyment, for your personal enjoyment. What he had there, when you agreed to this month to month, is what the benefit of the bargain was. You pay him this amount, and you get what you see. You decide, well, I want it to look better. You should have called him and said, hey, if I put fixtures in here, will you reimburse me if and when I move? Should have did that. If he'd have said no, you wouldn't get him. And so you have to have asked for him to put him under an obligation. Otherwise, the law says you cannot take fixtures with you.
The courtroom quiets as Judge Mathis delivers a clear legal principle. Fixtures cannot be removed or claimed for reimbursement without prior agreement. This statement is not just directed at Lionel, but at every tenant watching. It sets a precedent for understanding lease terms before making property investments. The judge's humor about taking your toilet with you lightens the moment, but underlines a serious truth. Ownership transfers once an upgrade is fixed in place. Would you risk spending your own money improving someone else's home without a written guarantee?
The only thing I took with me, obviously I wasn't going to take the sink or the faucets or anything, or the shower head. That was all there. The only thing I took with me was a ceiling fan that I put up and a fixed light fixture that was above the dining table.
Yeah, I'm not saying
that
you took those things. I'm saying...
No, I did take those and replaced it with the originals.
No, I'm saying the sink and all the things you've shown me that you want him to pay for. My point is, he doesn't have to pay for them, and you can't take them. You put fixtures in to his home by your own volition, without any agreement for reimbursement. So once they became fixtures, they were his. They were his. You put a toilet in, that toilet is his. You can't leave and say, give me my toilet. I'd fill it up for you. If you come to my house talking about give me my toilet, you get your toilet all right. Anyhow, that's the law. Okay. Can't take fixtures with you. I don't care who paid for it, unless there's a agreement ahead of time that that's going to happen. Any further comments or questions? No. Otherwise, your case is dismissed, sir. And you need to say thank you for upgrading my property.
Thank you, Mr. Mandrean, for upgrading my property.
And the man was there how many years?
He was there 8 years too long.
And this how you're going to do him?
Oh, I'm sorry.
8 years too long. He was all right until this.
Seriously, up until the end. I paid my rent every month. You never had a problem. I looked after
upgraded your property for you?
He upgraded the property for himself, sir, not for me. I didn't ask him to do that.
But it benefited you ultimately.
Fortunately, yes, sir.
Fortunate to you. Unfortunate for you. I wish I could give you something, but I got to go with the law.
Okay.
Good luck to you. Case dismissed.
All rise.
The gavel comes down. Case dismissed. The judge sympathizes with Lionel's effort, but reminds him that kindness and honesty do not always outweigh contract law. 8 years of loyalty end in frustration, yet the court remains bound by legal definitions, not emotions. Mr. Apple walks away relieved, while Lionel leaves questioning whether doing the right thing ever pays in court. Should laws adapt to protect tenants who improve a property in good faith, or should they remain strict to avoid endless disputes?
Judge Mathis has ruled in favor of the defendant. The plaintiff's case has been dismissed.
You know, I just felt that I laid out money that helped him sell his house.
I agree with the judge's ruling. This would be a very bad precedent for property owners who invest thousands of dollars.
Coming up.
We hear from you, sir.
Yes, sir. Basically, I am being sued for being a good neighbor.
You're watching Mathis Court with Judge Mathis. This is Mathis Court with Judge Mathis.
Benjamin Wright is suing Walker Eastman in the amount of $10,000. Mr. Wright claims he was arrested after his neighbor falsely accused him of driving under the influence and says Mr. Eastman's lies wrecked his life.
Alrighty. State your name, sir.
My name is Benjamin Wright, sir.
Yours, sir?
I am Walker Eastman.
All right, and sir, why don't you give me some background on this?
Yes, sir. I'm here today to sue my neighbor. We had an argument at my house. I left and I...
Just as emotions settle, a new conflict enters the courtroom. Benjamin Wright sues his neighbor, Walker Eastman, for $10, claiming a false DUI report destroyed his reputation. From landlord disputes to neighbor accusations, the courtroom shifts from property rights to personal defamation. How far should someone go when reporting a suspected crime? Does good intention justify harmful consequences?
You all been neighbors, or?
Yeah, we've been neighbors for about 3 years.
Have you gotten along?
Here and there. Some days we're good, some days we aren't.
The answer is no. Go ahead, you finish.
Yes, sir.
This time y'all doing what y'all do, arguing. Go ahead.
We had an argument. I was on my porch and he was standing on his property. I didn't want to argue with him, so I just left. Upon me leaving, I leave out my driveway. Say about a mile down the road, I get pulled over by the police. I was asked to exit my vehicle, and I asked them, I was like, why am I exiting my vehicle? I was actually told that my neighbor called on me and said that I was intoxicated. They gave me a breathalyzer test, passed the breathalyzer test. They still wanted to do further tests, so they took me down to the station where I took a urine test, passed the urine test. I'm kind of frustrated right now for the simple fact that my neighbor called the police on me, and I'm like, I should have never called them in the first place.
Coming up.
So I thought the best thing to do would be to let someone know of the potential danger of the situation.
And it just happened to be after you all having an argument. Got it. You're watching Mathis Court with Judge Mathis. This is Mathis Court with Judge Mathis.
Mathis Court is back with a case of Benjamin Wright, who is suing Walker Eastman for $10,000.
Did you walk unbalanced or something? Did they tell you to walk and you walked
Not at all,
unbalanced?
sir.
Let me hear from you, sir.
Yes, sir. Basically, I am being sued for being a good neighbor. We had words, as was stated. During this exchange, I smelled marijuana coming from my young neighbor, and he left in a state which left me in great concern.
What state? What type of state?
Well, he didn't seem completely in control.
Give me some examples of what he was doing that gave you that indication.
His behavior was erratic.
Give me some examples. Tell me what you saw.
I could maybe, he was like frustrated, and then he walked towards his car. He got in his car, he accelerated, he burned out. He burned up the street with what a casual observer would say an exhibition style. As far as I know, that is not legal.
Correct.
Deemed by most people to be a little dangerous.
Yes.
The tension rises as Benjamin recounts being pulled over, tested twice and cleared, yet humiliated. His neighbor admits he made the call out of concern, but timing suggests revenge after an argument. Judge Mathis zeroes in on motive, a crucial factor in defamation and malicious prosecution claims. Here the law measures reasonableness. Was there enough evidence to justify the report? The judge's reasoning connects directly to the idea of retaliation versus responsibility. If you feared a neighbor was driving impaired, would you report them, even at the risk of being wrong?
I couldn't go over and physically stop him because then I would have been the one getting arrested. So I thought the best thing to do would be to let someone know of the potential danger of the situation.
And it just happened to be after you all having an argument. Got it. All right, sir. Do you have the police report?
I do have a police report here.
Great. And then they'll tell me what they believe they saw and gave them the reasonable suspicion. That's what it must have. They must have a reasonable suspicion that you have broken the law when they stop you. Before police can search and seize, going through pulling your stuff out, pulling you out, searching your car, they must have a reasonable suspicion that you have broken the law.
How will Judge Mathis rule? Find out when Mathis Court returns.
You're watching Mathis Court with Judge Mathis. This is Mathis Court with Judge Mathis. We see double time salary. What is this? Attention to all staff. What does that have to do with anything?
Yeah, after I was actually pulled over by the police, After I was taken to the police station, I had to stay there for about like 4 or 5 hours. I had a big project that night. I was going to be pulling a double shift. Would have paid me handsomely, double the pay that I was going to be paid. They impounded my car. I had to pay extra $500 for that.
Yeah. And then they say you passed every test you took.
I passed every test, sir. Every test.
Sir, I believe you did it in retaliation to your argument, and he has proven all of the harm that he has endured, and therefore I'm going to grant his judgment. $10,000 for the plaintiff. You certainly put him in harm's way. You retaliated against him, which caused him significant loss and embarrassment, and I'm sure traumatized him, and so therefore I'm going to grant the entire amount. Have a good day.
All rise.
Judge Mathis has ruled in favor of the plaintiff. The defendant has been ordered to pay
After reviewing the facts, Judge Mathis rules in Benjamin's favor, granting $10,000 for damages caused by a false accusation. The courtroom learns that intentions alone cannot shield someone from liability. Good motives do not erase harm caused by reckless actions. This person seems to agree. Self-subtentio by 12 equal. Does this verdict seem fair to you, or should the neighbor's concern have excused his mistake?